Hello and welcome. It's great to have you. A few weeks ago, we talked about immigration scams that are directed at immigration applicants. Today, we will be talking about immigration fraud that is directed by the applicants or their consultants towards Canadian government. And we will try to understand how to avoid that kind of immigration fraud.
Just a quick reminder before we start. Please know that whatever you hear in these live sessions or any content you see on social media by Savirov's law firm is general information only and not legal advice. While we may use certain real-life scenarios or legal cases for learning purposes, it is important to remember that this does not constitute a legal opinion. For personalized legal advice, please consult with your lawyer or hire a Canadian immigration lawyer. Now, let's get back to our show.
As usual, we bring news pieces about Canada that might be relevant for you. News piece number one. OECD has published a report about foreign direct investment in figures. It's called, you can access it at this link. And this report highlights that after United States and Brazil, Canada is number 3 in receiving a big amount of foreign direct investment into Canada, into the country. So why this is relevant? Of course, US is by far the biggest recipient of foreign direct investment, but Canada is doing pretty well too. So investors are trusting and they rely on Canadian economy. They have a good positive outlook going forward. As an investor or business owner, this might be interesting to you. Go and read this report. As you can see, United States is a world leader in FDI. Brazil is number 2, and Canada is not too far away with $29 billion invested in this year alone. So you can read this report at the link. Next, the second piece that we have for you is related to tourism. GTAA, the Greater Toronto Airport Authority, released its third quarter results, which are relevant in terms of bringing the passenger flow into country to the pre-pandemic level. So we are making slow progress, but confident progress forward. As you can see, in September 2023, passenger activity recovered to 91.4% pre-pandemic passenger activity. So things are moving slowly to the right, in the right direction. You can read this report a little bit to understand what is the passenger flow if your business is related to tourism or side economies related, connected with tourism, and you want to do tourism business here in Canada. Canada has, as a government, municipalities, provinces, and federal government, they have a lot of support to revitalize, bring back tourist flows into the country. So these two pieces are for you to reflect in your free time. So now let's get back to our presentation about immigration fraud and how to avoid them.
Are you constantly on the move, managing your business, and looking for a convenient way to stay informed about expanding your business to Canada? Look no further. Introducing Speaking of Canada, the podcast that keeps you in the loop on all things related to Canadian business immigration, delivering the latest news and valuable tips and captivating interviews, no matter how busy your schedule gets. Speaking of Canada has got you covered.
Immigration fraud is a big topic in Canadian immigration system, and today's presentation will be longer than I usually do, so bear with me. This is a deep topic. I try to simplify so that you can benefit from it going forward. So let's first define immigration fraud. You remember we did a video a couple of weeks ago about type 1 of immigration fraud, where applicants are trying to defraud. Applicants are being defrauded by scammers. Around the world, there are many scams that try to lure victims, like probably most immigrant applicants have seen those scams. And we discussed that in our first video. In this video, which is a longer one, we will discuss immigration fraud and particularly misrepresentation in your immigration that is directed at Canadian authorities, at IRCC, Immigration Canada, or other authorities that deal with immigration applications. So it is a different type of immigration fraud when the applicant is trying to lie to Immigration Canada or hide some information, knowingly or unknowingly. So there are different scenarios we will be going through. So misrepresentation is a big issue related to that scenario of fraud. So today my presentation, as I said, will be a bit longer than usual, so I ask for your patience. Now, typical scenarios, you've heard about them, and typical scenarios are, black and white, and you understand that this is fraud and you know it. I will be focusing on the situations that you may not clearly differentiate. Is it a fraud? Is it a misrepresentation? Do I know the information? Did I disclose enough information to the Canadian government? So those gray areas, let's say unknown and confusing areas, will be the focus of my presentation. Typical scenarios: family reunification and spousal sponsorship fraud, marriages of convenience, getting married just to get the status in Canada, falsifying marriage certificates and whatnot. Applicants must prove to the visa officers that the relationship between individuals, partners or spouses, whatnot, is genuine and not entered into primarily for the purpose of acquiring any status or privileges under the law, the Immigration and Refugee Protection Act. So there are many marriage scams, Canadian citizens marrying some foreigner, representing that it's his or her spouse or partner, bringing them to Canada for certain arrangements. This is typical fraud, and the applicants know it, the sponsors know it, everybody knows it. It's just they hope that Canadian government will not know that it is a fraud. Recently, QAA, the specific visa for Ukrainian citizens, is becoming very popular because that benevolent, that good program is being misused by someone who wants to come to Canada by marrying a Ukrainian citizen, obtaining a work permit, coming to Canada, while Ukrainian citizen himself or herself is remaining in Germany or in Poland. They never wanted to come to Canada. It's just using the Ukrainian passport to get married to a foreigner, a non-Ukrainian, and helping him or her to come to Canada. The QAA, the specific visa for Ukrainians, that has been also subject to this kind of marriage fraud and marriage of convenience. Refugee claim and asylum fraud. Many people come to Canada, and we can see in our neighbor's situation in the US, the same situation. Many people come and they claim asylum, whether it's justified or not, whether it's well-founded fear or not. They apply for refugee status, again, with false information, false stories, or bases of claim. So claiming to be a refugee or an asylum seeker using false information. That's very typical, and we are not going into those details a lot. Benefiting from temporary work permit status in Canada. When you claim a refugee status or asylum in Canada, in the meantime, you are given work permit status, right? I've seen many customers of other professionals that provide. They mislead the lawyers. They mislead the immigration consultants, saying that I am a genuine refugee, but what's at stake is to get the benefits of that work permit. Maybe the refugee claim will be handled in 1 year, 2 years, 3 years. In the meantime, the person is remaining in Canada on a work permit, working, earning money, sending money home. That kind of scenarios are also present unfortunately, in Canadian immigration system. Benefiting, as I said, from temporary work permit status, getting social welfare from the government, the money from the government, or even when they are deported, government covers the deportation fees. Unfortunately, that's the reality that we live in, and we have to be very, very careful, because there are people who are abusing the Canadian law, Canadian welcoming immigration policies to benefit themselves in the meantime. And of course, black and white situation, blatantly lying about facts and faking, manipulating the documents in your immigration application. That's a very typical scenario. Claiming that you resided in Canada while actually you are residing in your home country. just to maintain your permanent residence status. There have been a lot of cases in the federal court. We will discuss some of them when people claim to be living in Canada just to satisfy the residency requirement of the PR, while they actually are living in their home countries. There are a lot of cases like that. Passport fraud, address fraud, employment fraud, and the creation of false immigration documents as if to satisfy the requirements of the program. So that's a typical situation. What's not typical and what's very, very difficult sometimes, and there are many cases about it, is misrepresentation. What is a misrepresentation? Did you hide some information which you thought is not relevant or material to the case? So it's a complex, all-encompassing topic, misrepresentation, and I think there's a healthy debate between the government, the IRCC, and the Department of Justice. They are trying to argue, usually, to limit the possibilities of misrepresentation. They go after each case to say that, yes, this was a misrepresentation and that was not a misrepresentation. And the Federal Court of Canada helps to distinguish what is or what is not a misrepresentation. Directly or indirectly misrepresenting things. So it's not that easy sometimes, we will discuss those scenarios, to identify whether that information was relevant, whether you knew that information or not. So directly and indirectly misrepresenting is a very common topic in court cases. Withholding information, that's again part of misrepresentation discussion that we will do. These are the difficult areas of law where people have two stories. Both of them are quite strong. They have arguments before the court, they have strong arguments, and then the court decides. So these are typical scenarios. What does the government say in general on their website? They say misrepresentation is a serious crime. It's serious crime to lie or send false information or documents to IRCC. This is fraud. It's called misrepresentation most of the time. Document fraud can involve either false or altered documents such as passport and travel documents. The stamps of that within those passports can be altered and used for certain purposes. Visas, there are a lot of fake visas, Canadian fake visas or other countries' fake visas. The stickers, like it's easy to produce those stickers. It's not that complicated in this day and age. Diplomas, it's very common. Diplomas, degrees, and apprenticeship. These are all called misrepresentation, and it's a purposefully left very vague understanding of misrepresentation. And it will be clarified on a case-by-case basis. So this is purposefully broad. Certificates of birth and other police certificates and whatnot. Government says if you lie on an application or in an interview with an IRCC officer, this is also fraud. And it's a crime, punishable crime. If you send false documents or information, government will refuse your application, and they may also do the following. They can forbid you from entering to Canada for at least 5 years, and even after 5 years, you will not be a credible person, trust me. The 5 years is, yes, nominal 5 years, but what happens after 5 years? Again, you are in disadvantage. So doesn't worth risking your whole life of possible good life in Canada by just misrepresenting something. They can also give you a permanent record of fraud in their system. All information that you send or say to government, IRCC, Immigration Canada, is kept on their databases, and this could be a permanent record of fraud with them. They can take away your status as permanent resident or even Canadian citizen. Many years ago, there was a situation where a Canadian citizen who has been a citizen for 26 odd years in Canada, it was taken away from him. The citizenship was taken away from him because initially the information was false. And they can have you charged with a crime for up to 5 years of imprisonment, as far as I remember. And they can remove you from Canada and send you to your home country. So there are many consequences that government warns us. And how does government act in this immigration fraud space? They work with their partners, okay? Government work with CBSA, Canada Border Service Agency, which is an investigative arm of IRCC. The RCMP, Royal Canadian Mounted Police, basically the FBI of Canada. Foreign police services, they ask information from your home country too, sometimes through embassies and other Ministry of Foreign Affairs. Offices that can identify, they can issue identity or status documents. They require independent, sometimes, information, not through you, but directly from the source of that document. IRCC is working with CBSA and the RCMP to phase in biometrics. Biometrics, many years ago, biometrics were not required, but then they came in. The biometrics came in. Why? Because biometrics will help to identify who that person is. And they will check those fingerprints against all the databases that are available at their disposal. The US database, the UK, New Zealand, Australia, European Union, United Kingdom, Interpol, Europol, whatever databases will be created in the future, they will double check against those databases. Biometrics will make it much harder for people to hide who they are, as I said. It will also help to reduce identity fraud. So in the light of, under the umbrella of misrepresentation and preventing immigration fraud, Canadian government is working day and night with their partners. So don't be naive when somebody says, oh, it's easy to cheat the government. Canadian government is so naive that they will trust any document that you produce. No, they do their own due diligence, and we've seen it in many cases. Now let's come to the boring part, which is the law and interpretation. The main misrepresentation clause is found under Section 40 of the IRPA, the Immigration Act, which reads the following: a permanent resident or a foreign national is inadmissible for misrepresentation, for directly or indirectly misrepresenting or withholding material facts relating to relevant matter that induces, that results, or could induce an error in the administration of the act. So I highlighted induces and could induce for a reason, because when you misrepresent and it doesn't result in some kind of a decision, it's still a misrepresentation. So it could induce. That's the argument. That's the broad definition of misrepresentation. Broadly worded on purpose, that specific provision in the act. No time limitation for misrepresentation. Whenever, after many years, if government finds that you misrepresented many years before, they can start an investigation. There's no time limit, okay? You cannot say, okay, 10 years have passed and I'm now at peace, nobody can find it. No, it's not like that. It could induce error in the administration at the time of misrepresentation. So no exceptions if a misrepresentation is made by another party without the knowledge of the applicant. So you cannot say, oh, my consultant, my ghost agent, he did the mistake, he did the misrepresentation. It's not me who did the misrep, okay? You cannot defend yourself by the actions of the third party. It's very difficult for you to make that argument in front of the government. Now, the good side is that IRCC has certain duties before they accuse you in misrepresenting your information. One, finding of misrepresentation must be based on a clear and convincing evidence. So IRCC, the visa officer, has to have evidence in their hand on the basis of which they are claiming the misrepresentation, right? Visa officers are required to give extensive reasons when making finding of misrepresentation. So it's not like, oh, I didn't like this document, you're misrepresenting. No, they have to have certain reasons and explain it in a letter. Before making the finding of misrepresentation, visa officers must give you, the applicant, a notice, a letter basically, and provide you with an opportunity to make your own submissions, which we call procedural fairness letter. Okay? They have to give you that opportunity to defend yourself basically. The notice must contain, that letter must contain enough detail to enable you, the applicant, to know the case that you have to meet. Okay, it cannot be a vague, okay, they have to show, okay, this is what you need to provide to us in order for us to believe you in a way, in simple terms. So these three principles are for you, the benefit of the applicants. The court have defined those principles, and you can use those principles if you are faced with misrepresentation claim. Common misrepresentation mistakes. We've seen in many cases from federal court, previous criminal record. People basically hiding previous criminal record. Charges, accusations, administrative penalties, all must be disclosed even if the police certificate that you provide is clean. You need to disclose your previous history with the criminal justice system. Even if your government gives you a clean police certificate, it doesn't mean anything in a way, because you may be hiding something behind. Even amnesty, you've been pardoned, there was an amnesty and you've been released from the jail, and your criminal record as such is clean, but you should mention that. In the Kazi case, nothing in the act, it's said that nothing in the act precludes finding inadmissible for misrepresentation someone who omits to divulge a previous arrest or even when an amnesty or a pardon was granted. So in certain countries of the world, people get accused of certain crime. When they are accused, then sometimes they have an amnesty, forgiveness, right? The government forgives you that. You should report that accusation previous dealing with the government's criminal justice system. Previous refusals. People hide their previous visa refusals from any country in the world, right? You should tell about your refusals from Canada, from US, from whatever country that you applied and you were refused before. You should tell that to the Canadian government. Sometimes people think that ETA refusals, which is electronic travel authorization, for certain citizens of certain country, you can come to Canada with an ETA. And if you hide that ETA refusal, that's also a misrepresentation. ETA refusal is considered a refusal, okay? So it's not necessarily the sticker that is attached to your passport. It also relates to that electronic travel authorization that you may obtain online if you are a citizen of certain country. And if you are refused that, you should also disclose that information. Past work experiences. Many people decide on their own that this work experience is not relevant. Why should I tell it to the government? No, you should list all the work experiences that you had and let them decide what is relevant or what is not relevant, okay? Family composition. Some people knowingly or unknowingly, they don't disclose their children's information, whether the child is born in the wedlock or outside of marriage, or they adopted a child previously, or previous spouses. They don't think that this information is relevant, or they genuinely forgot, okay? That's the situations that we will go into in a moment. Medical conditions. Some people hide their medical condition because for certain medical diseases, you may be found inadmissible to Canada. But medical conditions, you shouldn't hide. Don't hesitate. Many people get through certain medical condition in their lives. Disclose that information too. Fraudulent documents, which is very common in the international student applications, unfortunately. Fraudulent IELTS certificate. There was one case that we will touch upon in this presentation. Okay, not so common mistakes. This is the difficult one. Not so common mistakes are the intent. The accompanying or non-accompanying family members. Sometimes you disclose in your application that this family member is not accompanying with you. But after some time, they come with you to Canada. Is that a misrepresentation? That's okay. That's a debatable topic. People's intention may change. So when does that change? You need to inform Canadian authorities. The purpose of staying in Canada, the purpose of coming to Canada or staying in Canada. So duty of candor, we will discuss that. This is very, very difficult topic, and I And I'm a bit worried about the cases that are being developed by Canadian Federal Court, that the misrepresentation argument and misrepresentation, the notion of misrepresentation is becoming larger and larger. It now includes duty of candor, that you voluntarily should discuss the relevant information and your intent in advance, so that you are not found misrepresenting the information. So bank statement, the amount, sometimes people provide their bank statements. In certain period of time, the amount was this much. But when Canadian embassies, they call banks in certain countries, believe it or not, Canadian embassies, they call the banks, local banks, and say, we are from Canadian embassy, tell us the amount of that person in your bank. And certain bank laws are not that stringent in those countries. They tell the embassy, and the embassy finds out, oh, the amount was smaller, much smaller than what you show in your bank statement. That's where the misrepresentation comes in, and it's very difficult situation for the applicant, because he, at the time of application, didn't misrepresent. They used the money, of course, from, it's your money, you use it. But then Canadian government, the embassy finds out that the amount that you presented is much lower. And this could be construed as misrepresentation. And the last one, the very not common mistake, is absence of arm's length relationship. When you get a job offer from a family member, relative, cousin, uncle, or whatever, you need to disclose that. That's an obligation to disclose. Otherwise, you would be found misrepresenting, not giving the whole information, withholding relevant information. So when declaring employment history, you need to disclose any familial relationship with your employer, if there is such a relationship. Now, of course, another good news, there are exceptions. Even if you are accused of misrepresentation, there are two things that you can use to defend yourself. One is materiality. To be material, a misrepresentation need not to be decisive or determinative. It will be material if it's important enough to affect the process, not the outcome, the process itself. So a very typical scenario here in this case was to withhold truthful, relevant, and pertinent information may very well have the effect of misleading, just as to provide positively incorrect information. That's the conclusion of the court. Even withholding information can be construed that as if you are lying, okay? In a very simple layman person. Very important note here, I highlighted, misrepresentation to others, other institutions, private or other institutions, is not a misrepresentation if it's not made to IRCC. Here's a case. The applicant submitted fraudulent educational transcripts to York University to get admission to the program. The university admitted the applicant to the program. York University issued a letter of admission. That letter of admission is a genuine, because the applicant provided genuine transcripts to the IRCC and a genuine admission letter from York University. No misrepresentation was made to the IRCC. That's the case with Wang versus Canada. It's very troubling, to be honest. Misrepresentation should be misrepresentation to anyone, not only to IRCC. So it's the law, it's the case law. Maybe it will change. As I read here, misrepresentation to others but the IRCC is not a misrepresentation in that legal sense, the definition that we discussed under Section 40. Exceptions, as I said, materiality is one defense that you may use. Second is an honest mistake. There are situations in life where you do and to honestly believe that you are not misrepresenting. It's a human life. You don't know the information. It's beyond your control. So there are two approaches. First approach, for innocent misrepresentation, applicants must meet two requirements. One, that subjectively the person honestly believes that they are not making a misrepresentation, because either they don't have the information, they don't know about relevant information. And the second is that objectively it was reasonable on the facts that the person believed they were not making a misrepresentation. That's a legal formulation a little bit, but we will discuss it in a moment. The second approach is additional third requirement, which narrows the availability of the exception, is knowledge of the misrepresentation was beyond the applicant's control, which is now in this situation in Olumi case. Olumi was saying that, we didn't know that our immigration consultant was faking the documents and submitting on our behalf. That was the claim. They didn't know that the fake document was submitted on their behalf, but court didn't believe. They should have known. It was very obvious. So we will discuss that. Now let's do the case law. Let's take a quick break here and do the case law one by one, which is relevant for you.
To stay updated on all things related to Canadian business immigration, check us out on social media. Follow us on Instagram, TikTok, LinkedIn, Facebook, and Twitter for the latest news and updates. Subscribe to our YouTube channel and click the notification bell to stay informed about the most recent immigration news, interviews with top immigration specialists, and our weekly live shows. Visit our website at www.sabirovs.com for more information or to book a consultation with our team of experts.
Welcome back to a very long presentation. I understand it's very long, but don't forget, I'll get to your questions after my presentation. Now let's look at the case law. What does the real life cases before Federal Court of Canada tell us about an honest mistake? In the Osisanwo case, very interesting facts here. There was an applicant, the applicant was found inadmissible because she had listed her husband as the father of 2 children. Whereas in fact, he was the biological father of 1 child. Why this has happened? It's interesting. The couple, that husband and wife, had briefly separated 28 years ago. And during that separation, the applicant, the lady, had an one-time affair with another man. Then the couple got together again, husband and wife, reconciled, and neither of them suspected that the husband was not the father of that child in question, the second child. He fathered 1 child, that's fine, but another man fathered the second child apparently. This fact only came to light when an official at the IRCC ordered a DNA testing. I don't know how they came up to that conclusion to order a DNA test. Maybe they got suspicious, I don't know. And court doesn't really know why this DNA test was required, but they did the DNA. Despite the lack of knowledge on the part of the applicant, the woman genuinely didn't know that the husband was not the father, the biological father. She was declared inadmissible for misrepresentation pursuant to Section 40. But the court said, how could she know? Because there are so many families in the world in the similar situation. They don't know, they never had the need to do DNA tests for each child, right? An exception arises, the court concluded, where an applicant can show that he or she honestly and reasonably believed that they were not withholding material information. Yes, it came out later through DNA tests, but the father and the mother brought up this child as their own for many, many years. The birth certificate showed him as the father. But again, the DNA test showed something otherwise. And genuinely, court is reasonable and said, how would this woman know that she was lying? No, she genuinely believed that this is the father of the child, and she declared that as is in the application. So the court believed that the applicant, and they said it's not a misrepresentation in this specific scenario. So if you honestly and reasonably believe that you are not withholding information, material information, then, and it's something that was impossible to know until the DNA test, it could not be construed as misrepresentation. So that prior knowledge argument worked for her. Next one, I want to highlight a very important case for you is, I said that there's no time limitation for misrepresentation. In this case, Louis case, the applicant applied for PR under CEC class, Canadian Experience class, in 2012 and provided fraudulent letter of employment. Ultimately, her application was refused because insufficient language skills. Okay, that application is done in 2012. Then, in 2016, the applicant became a PR as a spouse of a Canadian citizen. Okay, that's a different application. 3 years later, the IRCC initiated an inadmissibility process against the applicant for misrepresentation in another application well before that 2016 application, right? So there's no time limitation. There's no statutory limitation that everybody will forget your misrepresentation after some time. No, it doesn't work like that. And the court said Miss Liu cannot, sorry for the misspelling there, Miss Liu cannot escape the consequences of her misrepresentation simply because her deception did not succeed in assisting her to obtain a favorable result on her CEC application, so the previous application. It doesn't mean, that's why it's not about the result, it's about the process. She cannot say, oh, that application was unsuccessful anyway. She cannot defend that with that argument. Such attempts to cheat this country's immigration system cannot be overlooked simply because they did not, in fact, induce an error in the administration of the fact. So, misrepresentation, regardless of the result, they cannot be allowed to cheat the country's immigration system. And the word could that I mentioned earlier in my presentation is contemplates the full range of errors in the enforcement of the act that were possible at the time of misrepresentation or a withholding of material facts relating to relevant matter was made. So the time limit is not applicable to misrepresentation. There is no time limit. It can come after many, many years. Another, misrepresentation of intent. We talked about it briefly. It's very alarming, to be honest, because the intent of the applicant may change. But in this specific case, Singh versus Canada, the facts were the following. A person came as a visitor to Canada, and in his visa application, the visitor visa application, he said, I want to visit my family. I want to spend my time with family. He then obtained a job offer in Canada and was waiting for an LMIA approval. There was waiting time. While waiting, his visa was about to expire. He extended, that's a second application, right? He applied for an extension of his tourist visa. And in that application, he stated that he wants to spend more time with the family, which was at that moment incorrect because he was waiting for the LMIA and job offer, right? Job offer was in the display in the background. The IRCC approved the extension. They said, okay, you can stay if you want to spend more time with your family, that's fine. Once his LMIA was approved, he then applied, he went to the Peace Bridge in Niagara Falls. He then applied at the border for a work permit. Then that's when officers said, oh, by the way, stop. You said you wanted to spend more time in Canada in your just previous application, and we gave you that extension. But actually, your intentions were to get a job. So that change, the declaration of intent in your application is very important. So if you have that intent to get a job, just say that. Dual intent is not punishable. Dual intent is not illegal. So he was refused and he was given a ban for misrepresentation of his intent to work in Canada in his prior applications. What was the court's position? The court said, and they clearly outlined, that there is a duty of candor to disclose all material facts relevant to entry or admission, including material changes in circumstances. If your intent has changed, you should inform them, even if no question is specifically asked by immigration authorities. That's very wide, and as an immigration lawyer, I'm a bit alarmed by this kind of sentence, because now you have to, you always worry, what should I disclose? What should I not disclose? You should over disclose in a way, right? An applicant has a duty of candor to provide complete, honest, and truthful information in every manner when applying for entry into Canada. So, the onus of submitting true and complete information rests on the applicant. The authorities should not ask one by one, what's your intent? Did you apply to LMIA? Are you looking for a job? No, these questions will not be asked by the immigration officers. They will not think on your behalf. You should think on your own behalf and be open and transparent, okay? So, an intention to mislead is not required for misrepresentation to occur. So, they can say, oh, I didn't want to mislead. No, it's you didn't disclose, you withhold your intention. So that was enough for the court to say that there's a duty and you should follow that duty and disclose everything when it comes to your intent of coming to Canada. The conclusion, I'm almost done. Thank you for your patience. The conclusion is, as we stand here today in November 2023, the case law is developing and it's always changing. So it's always, my number one conclusion is always talk to the lawyers. If you are unsure or there's an ambiguous situation, talk to the lawyer. Section 40 of the Act on misrepresentation receives a broad interpretation. That's the conclusion. In order to promote its underlying purpose, in order to protect the act, the law, okay? That is to deter misrepresentation, to stop misrepresentation, and maintain the integrity of the Canadian immigration process. So that's why it's purposefully broad, and it's being broadened by case all the time. Okay, any exception to this general rule is narrow, very narrow, and government is trying to narrow it even further, and applies only to truly extraordinary circumstances. In truly extraordinary circumstances, you can defend yourself against misrepresentation. That's why you need to be truthful and honest with your lawyer even before embarking on a journey to come to Canada. Be transparent. An applicant has the onus and continuing duty of candor to provide complete, accurate, honest, and truthful information when applying for entry into Canada. That's said. And misrepresentation is material even if it is important enough to affect the process, not the outcome. The process is affected and it's relevant. Misrepresentation need not to be decisive or determinative to be material. Okay, there's a case law when they say, oh, this wouldn't change the outcome anyway. No, let them decide what is material or not. You should just disclose, and it doesn't have to be decisive or determinative. An applicant may not take advantage of the fact that the misrepresentation is caught by the immigration authorities before the final assessment of the application. That was another bunch of case law, the cases that I had to go through, where applicant says, oh, the decision hasn't been yet made, but I updated my information. That's irrelevant according to the court, but again, this is an alarming statement to me. To materiality analysis, the materiality analysis that we said that it could be used as a shield to protect yourself, is not limited to a particular point in time in the processing of the application. So materiality is a continuous, and basically it has a continuum. The assessment of whether a misrepresentation could induce an error in the administration of the act is to be made at the time the false statement was made. So the timing is basically, according to the court, is immaterial, and the assessment will be done at the time of that the misinformation was submitted. Okay, helpful tips. What can you do? It's very confusing. I understand it could be a very boring topic to you too, but that's why the lawyers are there. One tip is over-disclose, okay? Disclose extra. Give them information that give them information about your criminality, previous rejections, order to leave. If you hide, that's a risk. Talk to the lawyer and say, yeah, previously inconsistent information. Sometimes you do a very technical mistake. That's okay. Just tell that was a mistake, please. And it's reasonable. There are human beings on the other side of the table. They will understand. It's okay to say, I'm not sure, to my knowledge, then omitting the information. You are not sure, just give it to them. Intent, so disclose and deal with it. If you have dual intent, just tell it. And say, yes, I want to come to Canada temporarily, but also I have an intent to remain permanently or do something else permanently or long term, and I have this application to be honest. Canada needs people. Canada needs honest people, so be honest with them, and it's not a sin to have dual intent, temporary or permanent or longer term intent. Educate yourself on your documents. What documents are being submitted by you or on behalf of you? If you are hiring somebody, an immigration consultant or a lawyer, whoever is helping you, make sure that you see the documents, what is being submitted. And because you cannot rely when the immigration officer says, oh, you misrepresented this document, this is a false document, you cannot rely, oh, I didn't do it, that guy did it. So you need to educate yourself on your own documents. Be extra careful when reviewing documents submitted on behalf of you, as you are a client of somebody else, especially bank statements, police certificates, and so on. Just double check, triple check. Review previous applications for consistency and inconsistency. Deal with inconsistencies. So you may have several applications before. You had some applications before. So see what have you already submitted or what you already told to the government. You need to make it consistent with your next application, right? If you see anything suspicious in the documents, lump sum deposits, do not turn a blind eye. If you see any manipulation of the documents, this doesn't sound right, inquire and dig deeper. As a lawyer, this is my own advice to myself. Dig deeper and explain in the submissions. That's what needs to be done if you're hiring a professional to submit the application on your behalf. Don't turn a blind eye and don't say, okay, do whatever you want. All I need is visa. No, don't do that. Remember the duty of candor. We discussed already. Full disclosure of relevant facts. And if you receive a procedural fairness letter, your only defenses are honest mistake and materiality arguments. Two things. Come with clean hands and say, yes, if you did a mistake, acknowledge a mistake. You said, yes, honestly, we did a mistake. Here's what actually is, this, and try to argue an honest mistake or materiality in your case. Finally, make sure you call and discuss this issue with your immigration lawyer. It's a serious matter. It's not an easy task. That's why I dedicated so much time to prepare this presentation and present it to you. If you are unsure, the best is to talk to a lawyer and then go with that advice, whether or not you should do certain things or not, okay? If you need an honest and good advice, check out our videos about immigration scams. That was previously a few weeks ago. And also contact us for your advice and honest, holistic guidance on business immigration to Canada. We've been doing it for over 10 years, and business immigration is our business. So talk to us, talk to our lawyers. We will try to guide you to the best strategy in your circumstances. Now I will take your questions. Let's take a quick break and come back with your questions.
Are you constantly on the move, managing your business, and looking for a convenient way to stay informed about expanding your business to Canada? Look no further. Introducing Speaking of Canada, the podcast that keeps you in the loop on all things related to Canadian business immigration, delivering the latest news and valuable tips and captivating interviews, no matter how busy your schedule gets. Speaking of Canada has got you covered.
Okay, we only have a few questions which are not quite relevant. I can see it on the screen. Let's see. Different question from the subject. Okay, that's fine. When will the next all program express entry, PR, draw, be done. Okay, I don't know. Government is not consistent. Traditionally, it used to be every 2 weeks, roughly every 2 weeks. But I think government has already reached the immigration plan for this year. So how many draws we have? We are, today is November 22nd, right? So we have another 2 or 3 draws, max 2 or 3 draws for this year. So we will see all programs draw is being affected by occupation-specific draws or francophone draws, so French-speaking draws. So that's, I don't know. The short answer is I don't know. I hope there will be 2 or 3 more draws, and one of them, at least one of them, will be all programs. I hope so. Thank you for the question. Okay, I think it was a very long and probably very boring topic today, but I hope we created a material that you can refer to when you are unsure about the information you want to tell to the government or withhold the information. I'm not proposing you to withhold. It's better to over disclose, as I mentioned in my presentation. But anyways, discuss it with your lawyer and then get his or her legal advice and act accordingly. See you next week. Have a great day.